So while a lot of sessions have happened so far, and you have gained extremely detailed knowledge about the indemnity, about the damages, about the liquidated damages. So I'll take one by one with the case and the real problem at hand. When we look at the contract, and what we do is sometimes we have a contract from the customer coming to us, or sometimes we take some previous precedent from the contract and try to put everything under the indemnity. Does it really work? So with one of the incident which we had, was we had our client who had signed a specific indemnity contract for a litigation which could come in potential litigation for the company. While the detailed indemnity agreement was drafted, the moment the litigation arose, when the parties tried to invoke the indemnity clause, were they able to invoke the arbitration clause? Answer is no, because also for indemnity it is like one needs to actually suffer those losses which Archana mentioned to it. So the contract of indemnity must be detailing it out. Every process of indemnity triggering aspect is extremely important for M&As, for long-term supply contract, for purchaser contract, to have a process of indemnity in place. Because while it is a champagne clause or it's a last minute debated clause, and people, the businesses most of the time pushes you that this is a legal call which you need to take, and it should not come in their way, and it should not be a showstopper. But having said that, it is important that we push the business back, saying that hey, you have to qualify the process today, otherwise tomorrow when we are in dispute, this clause may not be relevant for us and may be incompletely drafted. So how do we overcome that clause, and what are the key ingredients which one should mention? So when you are looking at an indemnity clause, one of the case law which I would refer to all of you to understand, because you are the draftsman, you are the negotiator for the indemnity. When you are on the buy side, we are on the sell side, you will take those arguments in place. So when you are taking those arguments, the one of the very interesting cases is Gajanan Moreshwar versus Moreshwar. It's a AIR 1942 Bombay. It's a Supreme Court case which has laid down extremely well principles about the indemnity, that this is not an exhaustive definition, and it would apply the same equitable principles which that courts of England has. So in an indemnity contract, when you are laying down the process, you will say I would trigger the indemnity as soon as the event occurs, whether it determines and it is being finalized by a highest court of law or not. So when you are initiating an arbitration or initiating a court proceedings for that indemnities, it will be prudent and relevant when your contract allows you to trigger the indemnity provision, as long as you are within the contractual rights to take that indemnity obligation.
Achromic Point.